She stood in a Lexington courtroom, composed, still, almost unreadable. No trembling hands, no visible grief. Just a 21-year-old woman in clean clothes, looking like she had somewhere else to be. Investigators had spent months building a case around her, and yet she remembered almost nothing. She couldn't explain the blood. She couldn't explain the silence. And she couldn't explain why, when police found what they found inside her closet, her first instinct wasn't to call for help. But her phone remembered. And what was buried inside it, deleted, hidden, erased, would become the most damning evidence in the entire case. 3 questions have followed this story since the beginning. Why did she hide it for so long? What really happened inside that apartment on Park Avenue? And if she truly remembered nothing, then why did she delete the photos? To understand what happened on August 27, 2025, you have to understand what Laken Snelling looked like from the outside. Because from the outside, the picture was nearly flawless. She was 21 years old, a senior at the University of Kentucky in Lexington. She was a student athlete, a member of the university's competitive stunt team, a full-contact sport that combines elements of cheerleading, gymnastics, and precision athleticism. These are not casual participants. Stunt athletes train year-round. They compete at national level. They are disciplined, physically capable, and used to performing under pressure. Snelling fit that world. By all accounts, she was someone who had built a life that looked together. A university student, an athlete, someone on a path. Her social media presence reflected the kind of polished, curated life that young women in competitive collegiate sports often maintain. Friends, team photos, a normal college existence. Nothing on the surface suggested anything was wrong. Nothing suggested she was carrying a secret that was about to collapse the entire life she had constructed. That is always the most difficult part of cases like this. The ordinary exterior maintained perfectly right up until the moment it isn't. And then, August 27th. It started with noises. Snelling's roommates had been noticing things that didn't quite line up. According to court documents, they had begun to suspect, or at least wonder, whether Snelling might be pregnant. They never confirmed it with her directly. But the question had formed quietly in the background of their shared living space. On the morning of August 27, 2025, at approximately 10:30 a.m., Snelling's roommates heard loud, unusual sounds coming from her room. The kind of sounds that made them stop, that made them look at each other, that required an explanation. When they asked Snelling what was happening, she told them she had fainted. She said she hadn't eaten enough and that she was going to see a doctor. What happened next is almost difficult to describe without pausing on it. Snelling left the apartment. She drove to a McDonald's. She ordered food. She picked it up. She then drove to the University of Kentucky Student Health Clinic. According to the affidavit, she did not go inside. She sat in the parking lot, and then she drove back to the apartment. No doctor, no hospital, no emergency call, just a drive-through order and a parking lot pause. When she returned, her roommates went to check on her. And when they looked inside her closet, they found an infant, a baby boy, wrapped in a towel, placed inside a black trash bag. They called 911. Officers arrived. The child was pronounced dead at the scene. From the moment police arrived on Park Avenue, something about the scene felt wrong. The infant had been hidden. That was not a question, it was a physical fact. The baby was not visible, he was not on a surface, or in a bed, or anywhere that suggested accidental concealment. He was in a closet, inside a bag, wrapped, tucked away. That level of concealment does not happen accidentally. It requires deliberate action. But investigators had more to work with than just the physical scene. Snelling was taken for a medical evaluation. She spoke to staff at the University of Kentucky Hospital. And what she told them there, the specific words she used, would become one of the most significant details in this entire case. She told hospital staff that the baby had made a whimper at birth. She said she guessed that he was alive. She described what she believed was fetal movement. Let that sit for a moment. She heard a whimper, she felt movement, she guessed he was alive. And then, by her own account, she passed out on top of the baby for approximately 30 minutes. And when she woke up, she saw him turning blue and purple. And she put him in a bag. Investigators were not prepared to move on from that detail quickly, and neither should anyone listening to this story. Because what Snelling described to hospital staff, a baby who made sounds, who moved, who was likely alive, would later be confirmed by the Kentucky Medical Examiner's Office. The infant, formally referred to in court documents as Infant Snelling, was born alive. His cause of death was determined to be asphyxia by undetermined means. He suffocated. The question that followed, the question that would drive this entire prosecution, was not whether the baby was alive at birth. The medical examiner had settled that. The question was, what happened in the space between when Snelling regained consciousness and when that baby ended up inside a trash bag in a closet? Police arrested Laken Snelling on August 31, 2025, 4 days after the infant was found. She was initially charged with abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. Serious charges, but notably at this stage, no homicide charge had been filed. The original autopsy results had come back inconclusive. The cause of death had not yet been determined with certainty. Investigators were still waiting. Snelling was booked into the Fayette County Detention Center, then released on a $100,000 bond. She was placed on house arrest and ordered to wear an electronic monitoring device. She went to live with her family in Jefferson City, Tennessee, roughly 200 miles from Lexington. She withdrew from the university. She was removed from the STUNT team roster. On September 2nd, she appeared before a Fayette County judge for arraignment. She pleaded not guilty. On September 26th, Snelling returned to Fayette County District Court for a preliminary hearing. She waived her right to that hearing, meaning she agreed to let the case move directly to a grand jury without a public presentation of evidence. It was a calculated legal decision. Her attorneys were not going to let prosecutors lay out the details in open court at that stage if they could avoid it. But the evidence was still being gathered, and some of the most important pieces had not yet been fully analyzed. If you follow real cases where the surface story and the true story are two completely different things, where the image someone projects is the last thing you'd expect to see shattered, this channel exists for exactly that. Her Case Files covers the cases that don't let go. Subscribe so you don't miss what comes next. Because what came next changed the legal landscape of this case entirely. Investigators had obtained search warrants for Snelling's digital accounts, her phone, her iCloud storage, her Snapchat, her Instagram, her Facebook. Digital forensics is not a quick process, it takes time. But what investigators eventually recovered from those accounts created a timeline that Snelling's version of events could not survive. There were pregnancy-related searches on her phone, search terms that spanned months, the kind of search history that suggests someone who knew, who had known for a long time, and was actively trying to manage information rather than seek help. There were deleted photos, photos taken during labor, images that had been erased from her device, but recovered through forensic extraction. These photographs did not tell investigators something they hadn't suspected, but they proved something critical. This was not a situation Snelling had discovered in the chaos of the moment. She had been aware. She had been documenting it. And then, she had tried to erase it. There were also messages between her roommates, Snapchat communications recovered during the investigation, in which the roommates discussed their suspicions about Snelling's possible pregnancy before August 27th. The social context around this event had been quietly building for some time. People around her had noticed changes. No one had pushed hard enough to get answers. and Snelling had apparently managed the secrecy with enough precision to keep the truth contained. Until she couldn't. In December 2025, investigators took another step. A subpoena, date-stamped December 9th by Fayette County Sheriff Kathy Witt, was served to the University of Kentucky Medical Center. The subpoena required the hospital to produce all medical records for Laken Snelling covering the period from August 2024 to the present. That date range is specific, and it is significant. August 2024, 1 full year before the incident. Investigators were not just looking at what happened on August 27th. They were looking at the entire preceding year. What medical care had she sought, or not sought? What had she known? When had she known it? What decisions had been made in the months leading up to that morning? The medical records subpoena suggested that prosecutors were constructing a detailed picture, not just of a single terrible morning, but of a longer pattern of concealment. Of choices made, one after another, over the course of an entire pregnancy. And in the background of all this evidence gathering, the Kentucky Medical Examiner's Office was completing its full, final autopsy report. The preliminary results had been inconclusive, but the extended analysis, the microscopic examination that forensic pathologists conduct when initial results do not provide clear answers, was still in progress. The case could not fully move forward without it. The final autopsy report arrived in early 2026. Infant Snelling was born alive, full term, and his cause of death was asphyxia by undetermined means. That word, asphyxia, is precise and it is devastating. Asphyxia means the baby did not die from a birth defect. It did not die from a pre-existing condition. It was not stillborn. The infant had entered the world breathing, crying, making the sounds that Snelling herself described to hospital staff. And then oxygen was cut off. By what exact mechanism, the examiner could not determine with certainty, but the direction that conclusion pointed was unambiguous. Fayette County Commonwealth's attorney Kimberly Baird later made the prosecutorial significance of this finding explicit. It would not be abortion, and it would not be miscarriage, she said, given that he was born alive and passed by way of asphyxia. What she was saying was this: the cause of death removed any remaining ambiguity about the nature of the case. There was no argument to be made that this was a pregnancy tragedy. This was a child who had been alive, who had made sounds, whose mother described him as moving, and who died from a lack of oxygen, in a closet, inside a bag, while his mother drove to a McDonald's. On March 10, 2026, a Fayette County grand jury returned its indictment. First-degree manslaughter, abuse of a corpse, tampering with physical evidence, concealing the birth of an infant. An arrest warrant was issued. Snelling was booked into the Fayette County Detention Center on March 12. She was released on a $10,000 bond, a fraction of her original bond, which raised questions among legal observers about the court's assessment of flight risk. And here is where the two versions of this story collide most directly, because there are two versions. There is the version that Snelling's defense will likely present: a young woman in crisis, experiencing a concealed and terrifying pregnancy alone, who gave birth without medical assistance, who lost consciousness, who panicked, who made catastrophic decisions in a state of profound psychological shock. A tragedy, not a crime. A failure of mental health resources, not a deliberate killing. And then there is the version that the evidence constructs: a woman who searched for pregnancy information for months, who deleted photographs taken during labor, who after regaining consciousness and seeing her infant in distress, did not call for help, who instead ordered fast food, sat in a parking lot outside a hospital she did not enter, and returned home, who then placed the baby inside a trash bag, who concealed his existence until her roommates found him, who initially told investigators she had simply fainted. These two versions of the same story cannot both be entirely true. The space between them, the gap between the narrative of shock and the narrative of deliberate concealment, is exactly where a jury will eventually be asked to decide what kind of case this is. One detail cuts through both versions with particular force: Kentucky has a safe haven law. Under that law, a parent can surrender a newborn at any hospital, fire station, or emergency medical facility. No questions asked, no legal consequences, no criminal charges. Snelling sat in the parking lot of a medical facility. She did not go inside. That gap is not a small one, and it became a central element of the prosecution's framing. On April 10, 2026, Laken Snelling appeared in Fayette County Circuit Court for her formal arraignment. She entered a plea of not guilty to all 4 charges. The courtroom that morning was quiet. Snelling was composed. Observers noted her stillness, the same quality that had been noted at earlier hearings. No outward display of emotion, no visible distress, the kind of controlled presentation that, depending on who is watching, reads either as innocence or as practiced performance. Her attorney, Brandon Marshall, has not made extensive public statements about the defense strategy. The case is still in its pre-trial phase. Evidence has been presented to the defense team by prosecutors. The defense is reviewing. Fayette County prosecutors, for their part, have continued to build their case methodically. No sensational press conferences, no dramatic public statements beyond what the legal process required. The Commonwealth's Attorney's Office has let the forensic record carry the weight. On May 14, 2026, just days before this story was compiled, Snelling appeared in Fayette County Circuit Court for a pre-trial conference. Prosecutors presented their evidence to the defense team. The defense is now expected to respond. A status hearing is scheduled for June 12. The case is moving forward. A trial date has not been set. The psychological profile of cases involving concealed pregnancies is one that forensic researchers have studied at length. What makes the Snelling case unusual, what makes it distinct from the broader category of neonaticide cases that criminologists examine, is the combination of factors at play. Most cases involving concealed pregnancies and infant deaths involve young women who are isolated, who have limited support systems, and who face extreme external pressure from family, culture, or circumstance around the pregnancy. The concealment in those cases is driven by fear of exposure and a complete breakdown of available options. What investigators found in the evidence record here complicates that framework. The digital evidence, the months of pregnancy searches, the labor photographs that were subsequently deleted, the Snapchat communications, the subpoenaed medical records, suggests not a woman who had no time to plan, but someone who had time and used it to conceal rather than to seek help. Whether that constitutes criminal intent is ultimately a question for the jury, but it is the question that sits at the center of every proceeding in this case. There is also the question of what she said, not just to police, but to hospital staff, that she heard a whimper, that she felt movement, that she guessed the baby was alive. These were not statements extracted under interrogation. These were voluntary disclosures made in a medical setting. And the medical examiner's final conclusion, that the baby was born alive and died from asphyxia, aligned directly with what she had described. Her own words became evidence against her. As of today, Laken Snelling is 22 years old. She is no longer a student at the University of Kentucky. She is no longer on the STUNT team. She is living at her family home in Tennessee, monitored electronically, awaiting trial on charges that carry a potential sentence of 10 to 20 years in prison. Infant Snelling, the baby boy found in that closet on Park Avenue, has no name in the public record. He is referred to only by his mother's last name. He was full term. He was alive. He was found cold to the touch inside a trash bag. The Kentucky medical examiner confirmed he breathed. The forensic record confirmed he was heard. And the prosecution has argued that the decision made in the minutes and hours after that breath, a decision made by the one person in the world whose job it was to protect him, is the decision this case will stand or fall on. A jury has not yet heard this case. Laken Snelling has pleaded not guilty. She is entitled to the full protection of the legal process, and that process has not concluded. But the questions that started this story remain. Why, if she remembered nothing, Were there photographs she felt the need to delete? Why, if this was a moment of pure crisis, did she stop for food before stopping at a hospital? And why, in the days that followed, in the weeks, in the months of house arrest, has she still said so little? The next court date is June 12. The truth, whatever form it finally takes, is still being decided. Some cases stay with you long after the facts have been laid out. Not because the story is unfinished, but because the human reality inside it refuses to be neatly filed away. A campus, an athlete, a normal Tuesday morning, a closet, and the space between what a person projects and what they are capable of. That space, in cases like this, turns out to be vast. If you want more cases where the image someone shows the world and the truth underneath it are two entirely different things, cases told carefully, with real evidence, and without flinching, subscribe to Her Case Files. Every story on this channel is researched, verified, and told the way it deserves to be told. We will be following the Laken Snelling case as it moves to trial. When it does, we will be here.